You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Intellectual property, often abbreviated as IP, shapes how organizations innovate, distribute, and consume software in the cloud. Governance of IP is not merely a legal concern. It is also a foundation for compliance, operational trust, and sustainable growth. In cloud environments, where services are built on layers of third-party components, open-source libraries, proprietary code, and APIs, the risk of infringement or misuse multiplies. The purpose of IP governance is to ensure lawful software use, honor licensing terms, and manage risks tied to patents, copyrights, and trade secrets. Like building with borrowed tools, cloud development requires knowing which belong to you, which must be returned, and which carry conditions of use. Disciplined IP management empowers organizations to innovate confidently while reducing exposure to costly litigation, takedown orders, or reputational harm. It also reassures customers and regulators that services are delivered on lawful and defensible terms. Intellectual property divides into several categories: copyright, patents, trademarks, and trade secrets, each offering distinct protections. Copyright shields original creative works like code and documentation. Patents cover inventions and methods that are novel, useful, and non-obvious. Trademarks identify the source of goods or services through names, logos, or marks. Trade secrets protect valuable non-public information as long as secrecy is maintained. In cloud contexts, these protections overlap constantly. For example, a cloud platform may hold patents on scaling algorithms, trademarks on branding, copyright on code, and trade secrets on configuration methods. Understanding these categories is essential for compliance and defense. Each requires different governance, registering patents or trademarks, maintaining copyright notices, or safeguarding secrets through contracts and access controls. Treating them interchangeably invites confusion and legal risk. By appreciating their differences, professionals can apply the right protections and avoid unintentional infringement. Copyright law protects original works of authorship, which in technology includes source code, APIs, and documentation. Unlike patents, copyright arises automatically when a work is created, without registration, though registration enhances enforceability. For cloud services, copyright governs code bases, training manuals, and even website content. Unauthorized reproduction, modification, or distribution of these materials can trigger liability. Developers often misunderstand copyright, assuming code snippets found online are free to reuse. Unless licensed, they are protected by default. Copyright is like owning written material. Just because you can copy a book does not mean you can republish it. Proper governance requires respecting license terms, attributing authors, and maintaining records of ownership. Organizations must ensure that contractors and employees assign copyrights for work developed under engagement, avoiding disputes later. Copyright establishes a baseline of lawful ownership that underpins every layer of cloud development. Patents protect inventions that are new, useful, and non-obvious, typically after examination by national offices. In software, patents may cover algorithms, architectures, or methods for delivering services. Cloud innovation has driven thousands of patent filings, from container orchestration methods to security protocols. Patents confer exclusive rights, enabling holders to prevent others from using the invention without permission. This exclusivity incentivizes innovation, but also creates risk. Inadvertent infringement can lead to lawsuits or licensing costs. In cloud environments, patents frequently apply to cross-provider technologies like APIs or scaling methods. Patent governance requires clearance reviews, defensive strategies, and awareness of active claims in relevant domains. Patents are like fences on intellectual land. They define what is privately controlled. Navigating them responsibly allows organizations to innovate without trespassing, balancing opportunity with caution in a crowded and competitive field. Trademarks protect identifiers that distinguish the source of goods or services, including names, logos, and symbols. In cloud, trademarks signal trust and brand recognition. For example, AWS, Google Cloud, or Azure are protected marks, ensuring competitors cannot exploit them deceptively. Trademarks require distinctiveness and consistent use, often with registration to enhance enforcement. Unlike patents or copyrights, they do not expire so long as they are actively defended. Trademark misuse, such as unauthorized co-branding or logo alterations, risks infringement claims and brand dilution. In cloud, respecting trademarks also involves ensuring marketplace offerings do not confuse customers by mimicking established brands. Trademarks are like flags on a ship. They show who owns and vouches for the service. By honoring trademark rights, professionals maintain trust in cloud ecosystems, preventing reputational harm and costly disputes with providers or competitors. Trade secrets protect valuable, non-public information maintained under reasonable measures of secrecy. Unlike patents, trade secrets are not published but guarded through confidentiality agreements, access restrictions, and operational safeguards. Examples in cloud include proprietary deployment scripts, customer lists, or performance tuning methods. The strength of protection lies in secrecy. Once disclosed without safeguards, trade secret status is lost. Unlike copyright, which arises automatically, trade secret protection is fragile, requiring disciplined governance. It is like guarding a recipe. Its value depends on keeping ingredients hidden. For organizations, trade secret management requires contracts with employees, partners, and vendors to prevent leakage. In cloud environments where data flows across jurisdictions and providers, ensuring trade secret confidentiality demands special vigilance. Misuse or theft of trade secrets can cause severe competitive and financial harm, emphasizing the importance of proactive governance. Open source software, or OSS, adds both opportunity and risk in cloud development. OSS licenses grant rights to use, modify, and distribute code under specific conditions. They are legally binding, not mere guidelines, and failure to comply can trigger claims or revocation. Cloud services rely heavily on OSS, from container runtimes to cryptographic libraries. However, each license carries obligations. Some require attribution, others mandate sharing derivative code. Mismanaging OSS is like borrowing tools without reading the instructions. Benefits are real, but obligations are binding. Proper OSS governance ensures that license conditions are honored, enabling sustainable use. Organizations must catalog OSS components, understand their licenses, and train developers on compliance. By treating OSS as governed assets, not free resources, cloud professionals avoid hidden liabilities while reaping the benefits of collaborative innovation. Permissive licenses such as the MIT license and Apache License 2.0 allow broad reuse with minimal conditions. They generally require attribution and preservation of notices but impose few restrictions on derivative works. This flexibility makes them popular in cloud ecosystems, where speed and innovation thrive on interoperability. For example, Apache 2.0 adds explicit patent grants, providing extra protection. Permissive licenses are like lending tools freely with the request to credit the owner. Organizations often prefer permissive OSS because it reduces legal friction, enabling integration into proprietary projects without copyleft obligations. However, even permissive licenses require discipline. Removing attribution or failing to preserve notice files constitutes violation. Permissive licensing fuels rapid adoption and commercialization but demands that professionals honor the lightweight conditions consistently, maintaining trust with the broader open-source community. Copyleft licenses, such as the GNU General Public License or GPL, impose reciprocal obligations. If code is modified or distributed as part of a derivative work, the resulting software must be licensed under the same terms. This ensures freedom is preserved downstream, but it complicates integration with proprietary systems. Copyleft is like sharing recipes on the condition that anyone who alters them must publish their version too. In cloud, GPL obligations become critical when distributing binaries or source. though use without distribution may not trigger terms. For organizations, failing to comply risks legal action and reputational harm. Copyleft requires careful governance, ensuring obligations are understood before integration. While it promotes transparency and community benefit, it also demands foresight, particularly in hybrid projects mixing open and closed components. Professionals must balance innovation with compliance, respecting copyleft's ethos and legal force. Network copyleft extends reciprocal obligations to services delivered over a network. The GNU Affero General Public License, or AGPL, is the most prominent example. Unlike GPL, which applies upon distribution, AGPL triggers obligations when modified software is provided as a networked service. This means cloud providers cannot sidestep sharing changes simply by hosting code rather than distributing it. Network copyleft is like lending equipment, with the rule that if you let others use it remotely, you must still share improvements. For cloud providers, AGPL raises significant governance challenges, as hosting AGPL licensed components may obligate disclosure of modifications. Compliance requires awareness and careful architectural decisions. Organizations that misinterpret AGPL risk exposing proprietary code inadvertently. Network copyleft highlights the evolving tension between open collaboration and proprietary service models, demanding vigilance in license management for cloud deployments. Dual licensing models combine open-source availability with commercial terms, allowing organizations to choose. A project may be released under GPL for community use, but also offered under proprietary licenses for enterprises that prefer flexibility. This model provides funding for developers while expanding adoption. For example, databases like MySQL have long used dual licensing. It is like offering free samples with the option to buy full-service packages. For cloud, dual licensing ensures providers can integrate projects without triggering restrictive obligations, provided they pay for commercial terms. Governance requires tracking which license path applies to each use case, ensuring obligations are met. Dual licensing balances community freedom with business sustainability, reinforcing that IP governance is not only about restriction, but also about enabling innovation responsibly. License compatibility is a frequent challenge in cloud, where components with different licenses are combined. Some licenses coexist peacefully, while others create conflicting obligations. For instance, mixing GPL components with proprietary code may require open sourcing the entire project. Compatibility is like dietary restrictions. Ingredients must be checked before combining them into a meal. Failure to evaluate compatibility risks unintentional noncompliance. Tools and legal review help detect incompatibilities early, preventing costly rework. Compatibility governance ensures that integrations align legally as well as technically, avoiding surprises at deployment or distribution. In cloud ecosystems, where speed often trumps caution, compatibility checks serve as guardrails, ensuring innovation remains defensible. Attribution and notice file requirements enforce transparency and recognition of contributors. Many licenses mandate that original notices be preserved in redistributed code, whether in binaries, source, or documentation. For example, Apache 2.0 requires inclusion of a notice file with credits and disclaimers. Attribution is like citing sources in academic work. Credit maintains integrity and honors contributions. In cloud, failing to preserve attribution may breach licenses even if technical use is lawful. Attribution is not optional, it is a condition of license grants. Maintaining notice files requires disciplined build and release processes, ensuring they survive packaging, containerization, or distribution. By embedding attribution practices, organizations respect communities while preserving compliance, reinforcing that professionalism in IP governance extends beyond legality into recognition and fairness. A software bill of materials, or SBOM, inventories components and their licenses for shipped artifacts and services. SBOMs provide transparency into dependencies, enabling customers and regulators to verify compliance. They are like ingredient labels on food. Consumers know what is inside, and whether it aligns with requirements. In cloud, SBOMs are critical for managing open-source obligations, detecting vulnerabilities, and demonstrating governance. They also support audits and incident response by revealing affected components quickly. SBOM discipline ensures that licensing and security obligations are visible, traceable, and enforceable. Without SBOMs, organizations risk hidden liabilities from unknown dependencies. By generating and maintaining SBOMs, professionals create confidence that services rest on lawful, managed foundations, building trust across the software supply chain. The Digital Millennium Copyright Act, or DMCA, governs anti-circumvention and notice and takedown processes in the United States. It prohibits bypassing technical protection measures and provides a framework for removing infringing content upon notification. In cloud, DMCA processes apply to user-generated content hosted on platforms requiring providers to respond promptly to valid notices. The DMCA is like a referee system. Complaints trigger investigation and potential removal, with safe harbor protections for compliant providers. Cloud professionals must design platforms with takedown workflows, preserving evidence while acting swiftly. Mismanaging DMCA obligations risks losing safe harbor, exposing providers to liability for user actions. Awareness of DMCA obligations ensures cloud services remain defensible, balancing free expression with lawful protection of copyrighted works. Patent indemnity and limitation clauses in cloud contracts allocate responsibility for infringement claims. Indemnity means one party covers costs if another faces lawsuits over patented methods or systems. For example, a cloud provider may indemnify customers against claims tied to its services. Limitation clauses cap liability or exclude indirect damages, balancing protection with sustainability. These terms are like insurance riders. They define who pays if infringement disputes arise. For customers, indemnity provides assurance that adopting cloud services will not expose them to unmanageable legal risks. For providers, limitations prevent catastrophic liability. Negotiating these clauses ensures risk is distributed fairly, aligning innovation with financial resilience. In cloud ecosystems, indemnity and limitations are critical tools for managing the dense landscape of patents and claims. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Dependency governance ensures that open source and third-party code introduced during builds is tracked, analyzed, and approved. Software composition analysis, or SCA, tools scan codebases to detect component versions, associated licenses, and obligations. By surfacing issues early, SCA prevents incompatible or risky components from entering production. For example, a GPL-licensed library may trigger obligations unsuitable for a proprietary SaaS product. Dependency governance is like inspecting ingredients before cooking. If something violates dietary restrictions, it is rejected. In cloud, where builds may integrate hundreds of dependencies automatically, governance is indispensable. Without it, organizations risk violating licenses or exposing themselves to unplanned obligations. SCA transforms compliance from a reactive review into a proactive safeguard, ensuring that every build aligns legally and strategically with the organization's intellectual property risk posture. Container image policies extend governance to deployment pipelines. Organizations must gate promotion of container images based on license allow lists, provenance verification, and compliance checks. For instance, images containing components under incompatible licenses should be blocked from advancing to staging or production. Policies may also verify signed provenance, ensuring images come from trusted sources. These safeguards are like customs checkpoints. Only approved goods pass through. In cloud-native ecosystems, where images can be pulled from public registries with ease, unmanaged dependencies create hidden risks. Container policies enforce discipline, ensuring that only compliant and secure artifacts support workloads. This governance integrates legal compliance into DevOps pipelines, reinforcing that intellectual property obligations must be honored continuously, not as a one-time review at release. SaaS redistribution analysis evaluates whether offering software as a service constitutes distribution under copyleft or network copyleft licenses. For traditional GPL, obligations generally arise when binaries are distributed, not merely hosted. However, AGPL extends obligations to network-delivered services, requiring modified source code to be shared even without binary distribution. This distinction is like lending books in a library versus publishing copies. The obligations differ. In cloud, where SaaS is the dominant model, misinterpreting redistribution triggers serious risk. Providers must analyze whether modifications to copyleft components used in services trigger sharing obligations and whether alternatives exist. Clear legal review and architectural decisions prevent accidental exposure of proprietary code. SaaS redistribution analysis ensures that business models remain compatible with license obligations, protecting both innovation and compliance. Contributor license agreements, or CLAs, clarify inbound intellectual property rights when organizations host or contribute to open-source projects. CLAs require contributors to affirm that they own submitted code and license it to the project under specified terms. This prevents disputes about ownership and ensures that downstream users can rely on the license. For example, a CLA may require contributors to grant a perpetual license to the foundation managing the project. CLAs are like title deeds for property. They confirm rights before transfer. In cloud, where enterprises often sponsor or host projects, CLAs protect against claims that contributions included unlicensed or misappropriated code. They also reassure customers that open-source foundations manage code responsibly. Contributor agreements strengthen the legal foundation of collaboration, ensuring open innovation remains defensible and sustainable. Third-party code vetting examines plugins, marketplace items, and code snippets for licensing and origin risks. Developers often import packages quickly, assuming public availability equals safe use. However, marketplace items may have restrictive licenses, incompatible terms, or even hidden malware. Vetting is like verifying the pedigree of a component before purchase. Trust is not automatic. In cloud ecosystems, where third-party plugins extend platforms, governance ensures that additions align with both license policies and security standards. Vetting involves reviewing licenses, verifying authenticity, and approving use before integration. Skipping vetting risks introducing obligations or vulnerabilities that persist across services. By institutionalizing third-party code reviews, organizations preserve legal defensibility while enabling innovation. This balance allows rapid adoption of new tools without jeopardizing compliance or resilience. Patent clearance reviews evaluate whether proposed architectures or features risk infringing on existing patents. In cloud, this often involves scanning patent databases for claims related to scaling methods, security techniques, or API processes. Clearance is like surveying land before construction. It identifies boundaries and prevents disputes. Without clearance, organizations may inadvertently trespass on patented methods, exposing themselves to litigation or forced licensing. Reviews may be internal, performed by legal teams, or external through specialized firms. For startups, clearance supports investment by proving risk awareness. For enterprises, it demonstrates governance and reduces exposure to costly disputes. Patent clearance ensures innovation proceeds confidently, balancing opportunity with diligence. It is a proactive strategy to prevent legal roadblocks and strengthen intellectual property resilience. Defensive publication strategies counter patent risks by establishing prior art. By publicly disclosing innovations, organizations prevent others from patenting them later, reducing future infringement threats. In cloud, where incremental improvements abound, defensive publications keep the space open for community use. For example, publishing details of a new deployment optimization method establishes a public record. This is like staking a flag on open land. It signals that the territory cannot be claimed exclusively. Defensive publications balance the desire for openness with the need to prevent competitors from blocking innovation through patents. They are especially valuable in fast-moving fields where formal patenting may be too slow or costly. By embedding defensive publication into strategy, organizations foster collaboration while protecting themselves from restrictive claims. Artificial intelligence and machine learning raise unique intellectual property concerns. Training data may contain copyrighted works requiring rights or licenses. Model weights themselves may be treated as protectable assets, raising ownership questions. Usage licenses define whether models may be deployed commercially or restricted to research. In cloud, AI services complicate matters because customers may assume ownership of outputs while providers retain rights to underlying models. This is like renting equipment. You may own the results of your work, but not the machine itself. Governance must address who owns training data, outputs, and models, ensuring contracts clarify boundaries. Mismanaging AI-related IP risks, disputes over ownership, misuse of copyrighted inputs, or violations of privacy law. By designing policies up front, organizations align AI innovation with defensible intellectual property practices. Code generation policies address the growing role of AI-assisted development tools. These policies define how outputs must be reviewed, attributed, and licensed. For example, if a generated snippet mirrors copyrighted code, professionals must verify license compatibility. Attribution may also be required if models embed open-source contributions. Code generation is like automated writing. The author must still ensure originality and credit where due. In cloud, where rapid development pressures exist, AI tools may tempt teams to bypass due diligence. Governance ensures generated code undergoes the same checks as human-authored contributions, including license verification and security review. Clear policies prevent accidental inclusion of infringing or non-compliant code. By embedding code generation oversight, organizations balance productivity gains with intellectual property integrity. Export control overlays intersect with licensing by restricting the distribution of certain technologies, especially encryption. Even if licenses permit redistribution, export laws may prohibit it without authorization. For example, strong cryptographic software may require compliance with US EAR or EU export regimes. These overlays are like traffic rules on bridges. Permission is not automatic even if ownership is valid. In cloud, where services span regions, export controls require careful tracking of where software is distributed or accessed. Failing to honor export restrictions risks regulatory penalties regardless of license compliance. Governance ensures organizations monitor both licenses and export rules, aligning technical deployments with geopolitical obligations. Export controls remind professionals that intellectual property governance extends beyond contracts, integrating international law into daily operations. Evidence for compliance is critical for demonstrating lawful intellectual property practices. Organizations must preserve SBOMs, license files, approvals, and policy decisions tied to releases. Evidence proves due diligence in the event of disputes, audits, or regulatory review. For example, producing SBOMs and approval records shows that all dependencies were vetted for license compatibility. Evidence is like receipts for purchases. Without them, claims of compliance lack weight. In cloud, where software supply chains are complex, evidence ensures defensibility. Automating evidence collection during builds and deployments creates reliable audit trails. This transforms compliance from reactive reconstruction into proactive assurance. By embedding evidence into pipelines, organizations sustain both trust and accountability, showing stakeholders that intellectual property is managed responsibly at scale. Incident response for IP claims requires structured processes. Notices of alleged infringement must be logged, investigated, and addressed promptly. This may involve takedown actions, substituting components, or engaging legal counsel. For cloud providers, DMCA takedown processes are common, requiring swift but careful action to maintain safe harbor protections. Incident response is like fire drills. Preparation ensures rapid, effective action when claims arise. Without playbooks, organizations risk inconsistent or delayed responses, undermining defensibility. Structured incident response ensures that IP disputes are handled lawfully and transparently, protecting both providers and customers. It demonstrates maturity, showing regulators and courts that claims are taken seriously. By embedding incident response into governance, organizations reduce risk from inevitable IP disputes in dynamic cloud ecosystems. Decommission and sunset processes manage the removal of components whose licenses no longer fit organizational risk posture. For example, if a dependency under AGPL creates obligations inconsistent with business goals, it may be replaced or retired. Decommissioning is like phasing out hazardous materials and infrastructure. Outdated or incompatible elements are removed to protect sustainability. Sunset processes require planning, ensuring continuity for customers while shifting to compliant alternatives. In cloud, decommissioning may involve migrating workloads, retraining models, or rebuilding pipelines. Organizations must document decisions, approvals, and transitions to prove governance. Proactive decommissioning prevents future liabilities, ensuring intellectual property practices remain aligned with evolving obligations and strategies. It demonstrates foresight, reducing the likelihood of disputes or compliance failures. Anti-patterns reveal common pitfalls in intellectual property governance. Examples include relying on unpinned latest container images, which introduce unknown licenses, omitting notice files, violating attribution obligations, or ignoring copyleft obligations in forks, creating exposure. These anti-patterns are like shortcuts in construction, faster at first, but leading to unsafe and unlawful outcomes. In cloud, where speed pressures are intense, anti-patterns erode both compliance and trust. Recognizing and naming them trains teams to avoid risky practices. By embedding controls to catch these patterns early, organizations prevent technical convenience from creating legal liabilities. Anti-patterns highlight that intellectual property is not abstract, it is a daily operational concern. Avoidance sustains resilience, ensuring innovation remains defensible and lawful in fast-moving ecosystems. From an exam perspective, intellectual property governance tests the ability to apply licensing models, manage SBOMs, and interpret indemnity terms in cloud scenarios. Candidates must reason about license compatibility, copyleft triggers, and network copyleft implications for SaaS. Questions may probe how to handle AGPL components, respond to DMCA notices, or negotiate patent indemnity. Success requires connecting theory with practice, recognizing why OSS governance is critical, how export controls overlay licensing, and why evidence strengthens defensibility. Exam readiness emphasizes integration. Managing intellectual property is not isolated but woven into cloud build, deploy, and governance pipelines. Candidates who master these links demonstrate maturity, proving they can align innovation with lawful and sustainable practices in professional contexts. In conclusion, disciplined license governance, SBOM visibility, and prudent patent strategies enable lawful and sustainable software use in the cloud. By respecting copyright, trademarks, patents, and trade secrets, organizations protect both themselves and their partners. Open source obligations, copyleft considerations, and network triggers require vigilance, while dual licensing and permissive models offer flexibility. Tools like SCA and SBOMs bring transparency to supply chains, while evidence, takedown processes, and decommissioning ensure defensibility. Avoiding anti-patterns prevents hidden liabilities, sustaining trust and innovation. Intellectual property governance is not about limiting creativity but enabling it responsibly. In cloud environments where collaboration and scale amplify both opportunity and risk, strong IP practices form the foundation for reliable, ethical, and compliant operations that can withstand scrutiny. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.